Hello, everyone, and welcome to our webinar, the Corporate Transparency Act. My name is Miranda Ward, and I'm one of the client relations directors here at Davis-Stirling. We are so thrilled to see so many of you here again today. And as per usual, we have a lot to get to, so I'm going to jump right in. But before I do, this meeting is being recorded. If you require closed captioning, please request it at the bottom of the screen. This video will be available on our YouTube channel, and it will be processed after, so probably a day or two. We'll go ahead and post that link in the chat if you guys do not already have access to it. We will be taking questions via the Q&A function to be discussed at the end of the program. If we don't have time to get to your question, please look to the next meeting. Now on to the presentation. Please welcome co-managing partner Laurie Poole and Natalie Stewart, president of CTA Review.
All right. Well, let's jump in. Hi, everybody. Thank you for joining us today. I'm glad that we are putting on this presentation of the Corporate Transparency Act, although I have to confess that I've kind of I had put my head in the sand about this for the most part of 2024. But now that we are on the cusp of September, there is no more burying your head in the sand about the Corporate Transparency Act and homeowners associations' obligations to report information. So the Corporate Transparency Act was passed by Congress in 2021, and it was a bipartisan bill. It is located, for those of you who want to look it up, at 31 United States Code Section 5336. And what the Corporate Transparency Act did is it created a requirement that beneficial owners of certain reporting companies, and these are all terms that we're going to go through today, have to provide certain information. And the objective of the Corporate Transparency Act, or CTA, is to make it harder for bad actors to hide or benefit from their ill-gotten gains through shell or opaque ownership company structures. In September of 2022, the reporting rule was issued, and that's found in Title 31 of the Code of Federal Regulations, Section 1010.380. So that's the rule that actually is implementing what the CTA requires for the reporting of information by beneficial owners. Now, if you actually look at the code, they actually talk about what the intent of this law is, really trying to target those bad actors. And they use terms such as malign actors seeking to conceal their ownership of corporations, limited liability companies, or other similar entities that facilitate illicit activity. God, it's just so scary, isn't it? Money laundering, financing terrorism, serious tax fraud, all of that. And also in the actual wording of the law, it talked about how money launderers and others are involved in commercial activity, and they intentionally conduct transactions through corporate structures in order to evade detection. And many layer such structures, much like the Russian, what are they called, Natalie? The Russian...
Marishka dolls?
Marishka dolls. And so I actually have Russian Marishka dolls. And so the layering is like this.
So I think right now you're peeling back the layers of the HOA that where the the actual beneficial owners are hiding
to get to this guy,
the
little guy. So that's, it's important to understand why this came about. And what it's trying to do. Obviously HOAs are certainly a hotbed of money laundering and financing terrorist activities. So,
Yeah, Laurie, I actually heard a story the other day. We're talking about the genesis of the Corporate Transparency Act on another webinar that I was participating in, and it was the government was trying to find out post 9/11 who owned some property that was near an airport, and it took years because the owner was hiding or covered, layered with a lot of different shell organizations, and they couldn't actually find out who owned that property. And thus, here we are, the Corporate Transparency Act, where every entity registered in the United States that doesn't qualify for an exemption must now disclose who their owners are, so that the government can find you when needed.
Well, we like to say that bad facts sometimes make bad laws. Not that I'm saying the Corporate Transparency Act is a bad law, but
Yeah.
take
Well, I
it
don't
for-
even know if that story is true. So it was anecdotal. So
Yeah.
possibly, but here we are today. And
So, yeah, so why don't we get into what all those terms mean, what I just summarized a little bit.
yes, and why HOAs are CIDs, condominium associations, PUDs, why we are here today. Well, most HOAs are created by registering with the Secretary of State or a similar bureau. I know we have, Laurie, again, we have people from all over the country on this call. So while we are California based, there might be some different nuances to how your entities are formed in your state. I know there's places with bureaus of conveyances and not Secretary of State necessarily. However, that's the term we're going to use most during this presentation, because that is, we are in California and that is how an entity is formed here. And once a entity is formed with the Secretary of State, they become what is known as a reporting company. And when you're dealing with the Corporate Transparency Act, we have to remember there are two different sides of this. There's the reporting company, which in our situation is the homeowners association, and then there are beneficial owners. These are our board members. So when you have a reporting company, that company must file what is called a beneficial ownership report, and that includes the information from their beneficial owners. It's all so new and really confusing, but basically the association has to disclose who their board members are. So in going through all of this, and if you've read the Corporate Transparency Act, it's very confusing. And there are a lot of questions on how to identify your beneficial owners. Again, Laurie is obviously on this call and she's an attorney, and you would, if you have questions about who your beneficial owners are, you should definitely discuss this with your legal counsel. However, most commonly in an association, those beneficial owners are going to be your board members. The most common question I get is, do we have to have our managers or our attorneys or our CPAs? Are these advisors also beneficial owners? And they are not. While they advise the board members are the people who actually have substantial control. And substantial control is the defining factor of who a beneficial owner is. And I also got questions just last week, is if a spouse of a board member would be considered a beneficial owner, or a I can't remember the next one. It was a committee member. Would that person be considered a beneficial owner? And technically, no. They might advise, especially not the spouse. The spouse might be pulling the strings behind the scene, but the beneficial owner, that board member, actually is the one with the vote and has the control. Same with committee members. They generally advise the board of directors. If your association has something different, then you're going to want to discuss that with your legal counsel, but typically that is the situation.
Yeah, and I think it's important to understand too, just going back a little bit, is the Corporate Transparency Act is really facilitated through the U.S. Department of the Treasury, and they established, there's a subset called the Financial Crimes Enforcement Network that we will refer to today as FinCEN. Those are the federal government entities that are facilitating the CTA and the reporting requirements. And FinCEN has some really good information on their website. They have a lot of FAQs, and there are specific FAQs for homeowners associations, one of them being our homeowners associations reporting companies. The answer from the FinCEN FAQ is it depends. HOAs can take different forms. And, if an HOA was not created by the filing of a document with the Secretary of State or similar office, then it's not considered to be a reporting company. They also have an FAQ on who is the beneficial owner of a homeowners association. So their general definition of who the beneficial owner is of a reporting company is an individual who directly or indirectly exercises substantial control over a reporting company. So their answer to who's the beneficial of a homeowners association kind of reiterates that, is any individual who directly or indirectly exercises substantial control over a reporting company. So those terms are vague. They're always, I mean, we're lawyers, so we can find vagueness and ambiguity in anything. So this, the terms are vague, but our best interpretation is that all the directors, all the members of the board who usually typically have very similar voting rights would be the beneficial owners of the company. I did like the FinCEN answer to the question of accountants and lawyers, are they beneficial owners? And the answer is generally no. So as a lawyer, I liked that answer.
Yeah. And I think that's because generally you're an advisor.
Yeah.
The board of directors does not force to take your advice. Same with the CPA, same with the manager.
Yeah, and I don't vote. I go to a lot of board meetings, but I don't vote. So
yeah, and dealing with the reporting companies, there also are a few. Oh wait, we'll get here first. Is it okay to just list our president? This is a very common thought. It's really not okay once you read the definition of what a beneficial owner is and who has substantial control. The president generally has no additional authority over the board. The board of directors all has equal voting power, would you say, Laurie?
Well, generally, there can be some situations where voting power might be based on ownership interest, and the ownership interest may not be equal. So, but for most residential associations, all board members have equal voting power. That's way more common than not.
Yes, and then also there is a little caveat as well, where if an owner owns more than 25% of the residential units within an association, they must also provide their beneficial ownership information. And that gets really important when you get those down to the small communities. That means any duplex, triplex, or fourplex, quadplex, or 4-unit development would definitely meet this requirement. And all beneficial owners, often those are unincorporated, and we'll go into what an unincorporated association and if they get to have an exemption or not. But those are generally, those can be unincorporated or not. I've seen both. So 25% ownership is also a thing that we're going to have to look at.
Yeah, so for newer communities where the developer is still owning a large percentage of the separate interests, that becomes an important understanding of who a beneficial owner is as well.
Yes, especially if they're phasing on new property. It's an entity that is created, that is operating, but is definitely not developed yet. That developer will definitely want to be included in the beneficial owner report for a while.
Yeah.
Okay.
Right,
so
yeah. So let's move on to HOAs are looking for a way out. They're looking for a way to say, we're not required, we're not a reporting company, so we don't have to file our beneficial ownership information with FinCEN. Well, I'm sorry, I have bad news for you, but most associations are not going to fall under any of the 23 exemptions of entities that are not required to file reporting information or report their beneficial owner information. Now, unincorporated HOAs, we think most likely are not required to file. And that's because, again, the language is an entity has to be created by filing a document with the Secretary of State. So I know in our state in California, even unincorporated associations have to file a statement of information every 2 years. But that's not creating the entity. So there really is no entity to create in that circumstance. So our best guess is that unincorporated associations are not going to be considered reporting companies. Again, keep in mind, it's vague, not very clear. Like I said, there are 23 exemptions of entities that don't need to report. Interestingly, Natalie, number 2 is a government authority. So the government that put this into effect, they actually don't have to report. So maybe that's interesting, maybe that's not.
Well, one of the big issues with the Corporate Transparency Act is that it does feel like it's beating up on the little guy. Because, outside of HOAs, this is every small business that's incorporated, every LLC, every S Corp, everything you've got going on in your life has to register. But the banks, the churches, the large organizations, the Wall Street guys, they don't have to register. And the thought is because they are already subject to other registration processes and guidelines, but it does feel a little pointed.
Yeah. Some of the other exemptions are, it says charitable exemptions. They're really tax exempt entities don't have to file. So entities that file under 501c. Now, I will just state right now, I am not a tax attorney. So all the references to the Internal Revenue Code, if anybody has questions about that, you might want to consult with a tax attorney, CPA, things like that. But generally, the 501c. I know some associations might be classified or file under 501c4, which is the social welfare. But for the most part, HOAs file under Section 528, so they don't fall under the tax exempt entity ... yet ? The other exemption that we see a lot that we've had to do a bit of a deep dive in is the large operating company exemption. And for an entity to qualify as a large operating company and be exempt from the filing requirements under the CTA, there are 6 criteria, all of which have to be met. For our purposes, the most common ones is that there has to be more than 20 full-time employees that the entity is employing directly, and that more than 20 full-time employees are employed in the United States. And then also, again, remember there's 6 criteria, all have to be met in order to be exempt. The entity filed a federal income tax for information that showed they had more than $5 million in, quote, gross receipts or sales. So the question is gross receipts, is the assessment income, the income that an association gets from the members and the payment of assessments. If an association has more than 5 million in assessment income, is that a gross receipt? I'm not a CPA, not a tax attorney, but I did reach out to a CPA in our industry and ask that question. And in his opinion, he felt that gross receipts would include the assessment income. It is reported as income. But again, your association should check with your CPA, your legal counsel, to see if you could qualify under that large operating company exemption. So HOAs that do employ more than 20 full-time employees and have more than $5 million in gross receipts, you might fall under the HOA, the large company exemption. But I think the takeaway here is most HOAs are not going to fall under any of the exemptions and will have to file.
Yes, and I think also the second takeaway would be, if you think you qualify for any of these, talk to your attorney. If you're unincorporated, just run it by them. If you are a 501c4, if you think you might be, I'm also not a tax attorney, but I've done a lot of research into this, and it looks like associations were 501c4s prior to 1976 when the tax code 528 came out specifically for guidance for HOAs. So if you're an older community, you might want to double check. And then if you're a large operating company, if you've got a giant community and you have over 20 employees and over 5 million in assessments, it is 100% worth it to get an opinion from your attorney.
Agreed.
And so moving forward, I think I skipped a slide.
Yeah.
What information do you actually have to report? There's also a lot of misinformation out there. It's not as bad as it seems. For an association, the FinCEN is looking for the legal name of the corporation, an address within the community, and the tax ID number. That's it. There's nothing else that your association has to report. No income, no anything about the association. This, again, their association is now the reporting company. Your reporting company has beneficial owners who are the board members. And this is where we are hearing a lot of pushback from the information that people do not want to provide. This is it. Full legal name, residential address, your primary residential address, that if you serve on a board and you don't live there, they want to know where you're actually living, your birth date, and a photocopy of your driver's license or passport. If you don't have one of those, there's a list of subsequent government issued IDs that you can use. That's it. No social security number, no email address, nothing, no phone number. None of that information goes to FinCEN. They're not going to send a blanket email to everybody that's registered. They have no interest in that. This is for knowing who is actually the beneficial owner of the reporting company, who they are, where they live, and just information to see if they're possibly what are they called? Bad actors?
Yeah, malign actors, bad
Malign
actors,
actors.
the
They
little,
want
you
to see
know,
the little doll. So they
the
want to know
little doll.
where you're living and who you are.
Yeah. So blood type,
None of
all my
that.
kids, they don't need to know any of that.
No, and I can't say it again. There's no requirement for a social security number. I don't know, that definitely got out there somehow, and I hear it every day. It is not required. Again, not required your driver's license. It's basically the information found on your driver's license. That's it. Name, address, birthday, copy of your ID. There's an additional person that needs to actually provide information for new entities. So a new entity, this is at this time, it's a community that's created after January 1st, 2024. So if you have a community right now that was formed at the beginning of the year, you actually already should have applied or registered with FinCEN. And you have 90 days to register if you're a new entity. Starting January 1st, that goes down to 30 days. So any new community, as soon as they register with the Secretary of State, is going to want to do their FinCEN BOI report as well. So the company applicant is somebody who also needs to report in addition to the beneficial owners. And that person is literally the person who filed that paperwork with the Secretary of State. So this could be, and I found there's a lot of people that do this. It could be somebody with a developer. It could be an attorney. It could be a paralegal. It could even be the manager. I was doing a new community and I said, we need the company applicant information. Do you know who actually filed the paperwork? And the manager came back and said, I did. And I was surprised. But I said, great, we need your information. And they're actually also not looking for the person who directed them to do that. They want to know the person who actually filed it. If that person feels more comfortable also including the person who directed them, they can accept up to 2 company applicants per application. So if you're a junior manager and you don't feel comfortable, have your information, and you want to say, you know what, the developer actually also asked me to do this, we'll need their information as well. Same information, name, address, birth date, photocopy of ID.
Okay. So, hopefully we have some management companies and managers on the webinar today watching. So kind of addressing what to do. Now, like I said, I admitted I had my head buried in the sand about the whole CTA for, until, recently. And it is amazing to me. I'm having conversations with board members and I'm asking if they're aware of what CTA is. And so many people are like me. They've been burying their head in the sand and they just don't know about it. So now's the time to really get the communication out for what this is and the need to comply. We're going to go over the deadline soon, but they are coming up. So, management companies, I think now is the time to really start communicating, educating your boards. You have all your board member contact information. I did see a management company, a large national management company last week sent out an e-blast to their board members because one of them forwarded it to me with information letting them know what the Corporate Transparency Act is, why they have to file the BOI reports, the beneficial ownership information, who needs to file. So getting the word out there, educating the boards is what management companies really need to be doing right now. I think management companies can also work with their boards, with the HOAs to develop a compliance plan, have the boards start thinking about how are they going to file. They can file online directly with FinCEN, and Natalie will get into this more specifically, but they all have to be there at the same time to file because all that information has to go in at the same time.
Let me jump in real quick because I feel like it's important right now to discuss the filing options. And like Laurie said, you can file at no cost directly with FinCEN. It's tricky. It's browser specific, and you have to have everybody's information on one machine. So if you can all gather around one computer and upload your ID and everything to that one person's computer, that's great. If you feel comfortable emailing your information to a board member to then house on that machine, that's also fine. It depends on the comfort level of the person and their private information and security, but FinCEN does give you that option. And this is another thing that FinCEN, their big marketing campaign as to why the Corporate Transparency Act is great. They say it's not that hard. And it really isn't for 99% of companies that aren't HOAs. You know, when it's just like a CTA review, we filed our paperwork. You know, we have 2 beneficial owners. It was super easy. It was really easy. You know, if you own a small company and it's just you, great, no problem. It's your information that you're putting out there. A board of directors who has 5 to today, I got one with 14 board members.
Ooh.
All of those people to collectively together to upload on the FinCEN website and then manage independently is very tricky. So you can also, I mean, you can file directly, no problem. It's free, no cost. Some management companies are offering this as a service. There's a lot of conversation now also whether or not management companies really want to be doing this, especially since a lot of them, you would then have a contract with your management company to provide a service for typically a year. And what if you leave that management company, your association chooses to leave? How do you handle that transition? I am confident that most management companies know how they're going to handle this, but it is part of the conversation that you're going to want to have if they're going to be continually updating your beneficial owner report, even if you're no longer a client.
Well, and one of the questions I would have for the management company are, what is their firewall protection? Like how are they guaranteeing that your personal information is not going to be hacked and out there? So those are all questions and discussions that boards should be having with the management companies.
Well, and they should have them with any of their providers.
Yes.
Anybody who's doing this as a service, there's third-party services like CTA review. You should definitely ask me how we're handling your information, and I will gladly tell you. But any company that's doing this should have protections such as that. And also, you know, there are attorneys that I don't know of any in California that are doing this. There are law firms, a few sprinkled around, and I believe there are also some CPAs that are doing this, but it's new. It's brand new. This is a brand new regulation. So it's new to everybody. It's new to me. It's new to Laurie. It's new to any organization that's doing this. So so just be on the lookout for your options. And there's also a requirement to update. Laurie, do you want to go over the update?
Yeah, sure. And I was going to just say, just in case anybody's wondering, at this time, Davis-Stirling is not offering the FinCEN filing service. There are companies like Natalie's company out there who are doing it. Natalie, your company does it only, you're only doing it for HOAs. Is that correct?
Oh, yeah, correct. We are, you know, I can a little further, I'll go over why I'm doing this, who we are, and our background. But yes, we are 100% HOA specific.
Okay. Yeah, so there is an update. The other part that management companies are going to need, what we think a management company should be doing with their boards, is developing not only the initial filing compliance, but an update plan. Well, because the information, we'll get into this a little bit more, but the information does need to be updated within 30 days of a change in the information, specifically a change in the beneficial ownership, you know. So if there are new board members, then that information has to be changed. And it is, yeah, okay, let's get into that. So any change in the information has to be updated within 30 days. I think for HOAs, the most common situation that's going to trigger this update is new board members. So every year after the annual election, if there are new people on the board, then that information needs to be reported. And Natalie, correct me if I'm wrong, but when the new person's information has to be reported, everybody's information has to be reported as part of the update. Is that correct?
Yes, because there's no actual update process. It's not as if you can just send in John's new information because Janet is off the board. You have to submit the entire BOI report again, which is troublesome because if you've got somebody, maybe John, who was on the board, maybe he was managing this, maybe he has all that information and he was going to be the team leader for the future. And now you have to pass that off to somebody else. And now you're passing your information again and again. So yeah, it's within 30 days. It's not difficult, but it's time consuming and they don't make it easy. There's no update. It's the entire report again with everybody's information one more time.
Yeah. So again, the most common situation that's going to trigger it for HOAs, and it is going to trigger it potentially every year, maybe even throughout the year. If you have a board member who's resigned and you appoint somebody to fill that vacancy within 30 days, you got to go through the whole rigmarole all over again.
Laurie, what if we'll have board members that resign at a meeting and they don't have somebody to appoint right now. If that means in that 30 days, you have to file an updated report with that board member off, and then another report when you've appointed somebody. So there's all of these nuances that 30 days is not a long time.
Yeah.
And, especially in associations where it's not easy to find board members.
Yeah.
And you've got people that are coming off at any time. So it can be a lot of updates if needed.
Yeah. Now, some of the other things that trigger the update are if there's a change to the driver's license or the passport. Expiration is not a trigger to update. So if your driver's license is expiring and you renew it, that is not going to result in having to update. But
it will only trigger it, Laurie, let me jump in, if something material on the driver's license changes. And I'm finding out now how many married women wait a really long time to change their name. And so they do it when they maybe refile their driver's license, and they do all the paperwork at that time, even though they got married 7 years ago. And now they finally have a new ID with a new name on it. That's a reason. And California, when you renew your driver's license, the number doesn't change. Right. If you renew your passport, it does. So if your passport expires and you get a new one, they will need a new copy of that passport. And I know there's some states, because I've done, again, a lot of research, that have changed their driver's license numbering system over the years. And so when you renew, you're going to get one of those new numbers. If that's the situation, then you would have to update again. But just an expired license is not a trigger to file an update.
Yeah, good point. And if you change your residential address, now again, for HOAs, it's probably not going to come up too frequently, because if a board member is changing the residential address, most likely they are not living in the community anymore and they wouldn't be a board member. But not necessarily. Board members can continue to own property within the association, but they maybe move. We have a lot of people moving out of state right now, so maybe they're moving out of state, so that's going to trigger it if they stay on the board. So again, yeah, Natalie's right. Natalie, are you finding, because again, you can choose between your driver's license or your passport. Are you finding a pro or con as to which form of identification might be more preferable to use?
No, honestly, the passport, like conceptually, it doesn't have your address on it. So maybe that wouldn't change, but then if it expires, you would need to do another one. So no, I don't see a pro or con with either one of them, honestly.
And keep in mind too, that we're talking about the individuals, but sometimes, and it doesn't happen very often, but every once in a while, an HOA may change their name. So if the HOA's entity, if the entity itself changes its name, that will trigger an update as well.
Yes. Okay. So, I'm just going to jump in here. We kind of talked about this a little further and how to update the BOI file has to be updated the entire thing again. And previous submissions. This is another really great feature about the FinCEN website. When you file your BOI report, you have one chance to download it. So if you download it and maybe you're on your phone, you think we're just going to do this on my cell phone. It's gone if you don't save that PDF. The FinCEN database is 100% private, which means you can't go back and search. You can't go back and request a copy. It's gone forever, which is why also using a third party or somebody who has the software developed to save those reports. If anything happened in the future, because I'll jump to the next slide, the reason we're all really concerned is that there's penalties involved. If you ever got in a situation where you had to prove you filed and you've lost your report, wouldn't it be great if you could call somebody and say, I would like the last 5 updates, please? and your service provider could then send them to you. Instead, you're going to say, I don't know, Mary had one, John, he moved, he did the initial one. Like, that's a very uncomfortable situation when you're trying to defend yourself to the United States Department of Treasury. So, and we're doing this, Laurie, because of these penalties, right?
Yeah, so these are the penalties that FinCEN has implemented and are going to implement supposedly. So, you go, well, what if we don't comply? Well, here's what if. If there's failure to comply, then it is a $591 per day civil penalty. And you may wonder why $591. And if you Google it, which I did earlier this morning, you'll see a bunch of things that say 500. So you're wondering, like, where are we coming up with the 591? Well, they're adding inflation to that civil penalty. So since it was initially 500, but now because of inflation, it's $591. And guess what? That number is going to keep going up as inflation goes up.
And
so,
you know what, Laurie, thinking about it, because FinCEN has come out and said, we're not looking to use these penalties as a gotcha. January 2nd, it doesn't mean your association is going to be penalized. You're not going to start accruing these if you don't file by January 1st. It's possible that they could penalize you, but that's not what this is. It's not going to be a blanket enforcement over every entity that did not file. But if they weren't concerned about the penalties, would they have increased them recently in April with, looked at them and thought, wow, we didn't account for inflation on these penalties we're not planning on using.
Yeah.
I feel like that justifies the fact that they probably are planning on penalizing somebody.
Now, and so it is, as Natalie indicated, the penalties will be imposed for willful failure to report complete or updated beneficial ownership information. So again, we talked about the updates. It's not just failing to comply with the initial filing, it's failing to update as well within that 30 days. The other penalty, which is probably a lot more daunting, is the $10,000 and 2 years in prison. Now, Natalie, I don't know how we're going to be sending a corporation, an HOA, to prison. So my guess is that the beneficial owners who willfully failed to comply would be the ones that would be serving that prison time, and not the HOA entity itself, because you can't send an entity to jail.
Yes, and I think the willful non-compliance is one of those things that's key in this. You have to willfully non-comply, which is why it's so important for managers to advise their associations of this regulation, so that everybody knows that they're not accidentally not complying, that your managers are doing your job, so that everybody can follow suit and do what is needed.
Yeah, and one of the things we talked about was, okay, 4 out of the 5 directors submitted their information, and you've got one that's a holdout. And now we're getting close to January 1. Should the association go ahead and file without all the information? And both Natalie and I agree that, again, it's willful failing to report. So we think, substantially comply as best you can, get that information in. If the 5th director provides the information, then you update when that information comes about. And I do have a little bit later on, we'll talk about maybe some ways to incentivize directors to cooperate. So what are the deadlines?
Oh, we got to do this now. They expect you to start filing ASAP. The deadline to file, and this is like the deadline. It's not when you should file. This is the deadline to file, is January 1st for existing entities. And that means any entity that was formed prior to January 1st of this year. So this is most of our associations. New entities, you have within 90 days of filing date this year. Next year, it's within 30 days of your formation. So starting January 1st, new entities, 30 days from formation. Yeah.
So, Natalie, again, admittedly, I've had my head buried in the sand, but what should we be, telling our communities? I think based on this, I really do think that associations that have had their annual election already this year, you really need to be gearing up now and starting to prepare now for the filing.
You should 100%, sorry to interrupt, you should 100% start now. It is very difficult. board members are on vacation, board members are busy, board members don't check that email you sent that request for information to anymore. There's a lot of those nuances that it are very difficult. One board member might have more questions, understandably so. There are people resigning from the board because of this. There's a lot of things, and it's almost September, right? That's pretty soon.
Yeah.
So what that's September, October, November, December, 4 months
Yeah.
to figure this all out and to get filing. And I 100% anticipate the FinCEN website crashing at some point at the end of the year. I cannot possibly see it handling the volume. It's already slow. So I cannot imagine the volume going through. So now is the time to start. And if you know your annual meetings in October, that's great. That means you know that right after you get those board members, you're going to pull the trigger. So you have a plan.
Yeah, but keep in mind that annual meeting may not actually happen in October because you may not reach quorum, and it may not be until November. So I would say if your annual meeting is like maybe September, maybe the beginning of October, maybe you can wait, maybe. But you also know the information for the directors. If you serve staggered terms, there are directors whose terms aren't up for election. So especially if you're going to use a third-party company, start getting that information to the third-party company now. You can always update it after the annual election. Natalie, what did you tell me about how long on average it's taking for boards to get all the information to you so that you can do the filing?
4 to 6 weeks minimum.
Yeah.
And that's for like 3-member boards. Like this is and again, I'm not saying it's a bad thing, but there's always a holdout who wants more information, who's waiting, and we'll talk about this at the end of the presentation for that Hail Mary exemption to come in. And I understand it. I fully do understand it, but starting now is very important, because then there's the board members that are like, sure, here you go. Let's, so those people, get them out of the way, and then we can focus on the people who need a little more communication.
Yeah.
But
so I think one of the concerns that I'm hearing about people not wanting to do this is again, it is, although it's not social security number, it still is personal identification information. So who's going to have access to that?
Well, right now it's actually a tiered approach. So if you look at FinCEN has a plan to release this information to people who need access. And again, all of these people are under the guise of terrorist funding, money laundering, tax evasion. So the federal government agencies will have it immediately. And then below that, it goes to state and local tribal law enforcement, foreign requesters, which is the one that really people want more information about. What type of foreign requester is now going to have information or be able to request my beneficial ownership information? Financial institutions. So are these banks? Yes, these are banks. These are financial institutions who need to request information due to due diligence on customers, federal functional regulators, and treasury personnel. Now, this is all tiered. So immediately we won't all get information. And if you're really interested, there is a very detailed process in which these agencies have to apply to get that information, and a very, very regimented way they have to keep that information private. So it's not just like the IRS is going to get all of your information right away. They might have it for a reason. They need a reason, a genesis to apply for that information, and then possibly they'll be granted access.
Yeah.
So,
okay. What other? Yeah, go ahead.
I was going to say, this is the biggest concern, and it's the privacy and the liability, because there's the concern about the liability at the government level, like who is FinCEN? How are they keeping our information private? We can never make any guarantees on that. There's nobody here on these calls, no attorney, no tax professional, no advisor that can say that your information is safe in FinCEN. FinCEN is going to try to make it safe, but I'm sure we've all seen, recent hacks with our information and all of that stuff that has happened very recently. So I'm not here to make any warranties or guarantees that nothing will ever happen at the FinCEN level. Management companies are very concerned, because if they are collecting this information, how are they going to correct? This is considered PII, which is private or personal
identification information.
Identification information. Thank you. It is not SPII, which is special personal identifiable information, which means like your social security number and that kind of information. This is just standard PII. And the record keeping of these BOI reports. A printed BOI report, if anybody has not seen one, it has basically all of the information that is submitted to FinCEN, with the exception of the actual copy of your ID, but has your name, birth date, address, driver's license number, or passport number. So that's considered PII. And if a homeowner or an oncoming board member wants to say, can I see a copy of our BOI report? Is that a document, Laurie, that they can request?
Not at this time. I don't see Civil Code Section 5200 being having the BOI information as part of the document. But and we can talk about this a little bit later. There is actually a bill in front of the California legislature that is a similar CTA requirement for that could be California law as well.
Yeah, New York actually has a New York Corporate Transparency Act. So this isn't the first we're going to hear of something like this. So we're all going to kind of have to wrap our brains around it, especially in California and the other states that have this coming. The benefit of using like CTA review is that we provide a redacted report to the HOA. So you can show a redacted report to whomever, keep it in your board packet that states the filing information for that BOI report and the beneficial owners of record, just their names. And that's so that the managers can have it at a board meeting. The board members can look at it and say, wow, we need to update our report. This is who we have registered now, and we're going to need to update that. So that's
I still say it's not open for members' inspection rights. It is not an association record that is under Civil Code Section 5200. So
yeah, the actual beneficial owner report wouldn't be. We just feel it's necessary to provide a working document so that people can have something to refer to.
Well, and to prove that they did not willfully not comply with reporting. Yeah, exactly.
100%. So let's go here now. Laurie, we've got some current legislation. Is anything going to pass right now?
The wheels of legislative process do turn slowly indeed, don't they? So again, like Natalie said earlier on, for all those communities out there that either were burying their head in the sand like me or waiting for a Hail Mary, I really just don't think you should hang your hat on any of these proposed bills passing that's going to prevent at least the initial filing. The most encouraging one we've seen was introduced just last month in July, and that's HR 9045. And that would amend the Corporate Transparency Act to add under the tax exempt entity exemptions, it would add specifically an entity subject to taxation under Section 528 of the Internal Revenue Code. So that would exempt specifically HOAs that file under Section 528. But it was just introduced last month. It's currently in the House Committee on Financial Services. The chances that this is actually going to be signed into law and passed before January 1, 2025 is very slim, in my opinion. Same with some of these other legislations. And you can see there's proposed bills to, repeal the CTA in its entirety. There's some of the bills to extend the deadline for the initial reporting, things like that. But a lot of these haven't had any movement really for the better part of this year. So
I would say none of them have had any movement.
Yeah,
I look at them every day and to see if anything has changed. And they're all sitting there in this political climate. This isn't what's being focused on in Congress or the House, right now.
Yeah. What you mean, exempting the poor little HOAs from having to supply some information to the federal government?
And we'll talk, we'll go to this next slide because CAI, which I'm sure hopefully everybody on this call is familiar with, they would love for you to go to their website and fill out the call to action for HR 9045. And while it doesn't feel like you're doing much, right? You're just clicking through and you're sending this letter to your state legislator or your federal legislator through their office. If they got thousands of these requests, they would notice it. it would get on their radar. And that's what we're looking to do. So then when our advocates in DC and our lobbyists and the people we work with go to talk to the state legislators, they know what we're talking about and they can see that there's people behind it. So it just feels very not productive. It's incredibly productive. But Laurie, do you want to go into a little more about what CAI has done for?
Yeah, CAI has done a lot, and I actually was part of a task force. I am a fellow of the College of Community Association Lawyers, and there was a very small task force of CCAL fellows that did look into filing a lawsuit, interviewing law firms that could file a lawsuit on behalf of CAI and its members to say that the Corporate Transparency Act is unconstitutional. And moreover, as applied to HOAs, that there should be an exemption for HOAs. So we did that. We made a recommendation to the Board of Trustees, which they accepted. And my understanding is they're in the process of filing a lawsuit. Again, the chances that a lawsuit is going to stop this from going into, before January 1 is very slim. But it's important to understand that there was a lawsuit in Alabama that was granted on behalf of the Small Business Association Administration, something like that. And in that case, there was a stay. FinCEN put a stay on that organization and its members from having to file their beneficial ownership information. So should something like that occur, it would be to CAI and its members. So a reason to perhaps consider joining CAI if you're an HOA, that you would fall under the membership umbrella should something like that happen. But yeah, CAI also has been involved in advocacy. I'm sure they were helpful in the HR 9045. CAI through CCAL filed an amicus brief in the appeal of the Alabama case. So there's been a lot of, and certainly the media campaign from CAI. So there's been a lot.
And I actually was emailing with Dawn Bauman a little earlier, and because we know, is the lawsuit filed? When's it going? She said soon, not this week, which makes me believe that it's really soon. Because not this week means it's going to be a very early, subsequent week, I think. So keep your eyes peeled. I'm sure CAI National will let us know when they're doing that.
My understanding is the lawsuit was going to try to seek some immediate relief too, maybe an injunction or something. Again, I'm not directly involved in that anymore, but
yeah, we haven't seen it. I'm sure it's going to ask for immediate relief, and then ultimately, Laurie, isn't this all going to potentially go to the Supreme Court?
Oh yeah, I think undoubtedly, because there's other lawsuits, that the Alabama one, the CAI one. There's a firm
There's
in
8 that I've counted.
Least. There's a firm in Massachusetts that filed a lawsuit on behalf of its HOA clients. So anyway, I want to make sure we get through the last couple of slides real quick.
Yeah, let's skip the FAQs because I think we got through this, and let's go to the what you're recommending on possible government document changes.
Yeah, so in looking at the information on the FinCEN website, and I actually had been, once I got my head out of the sand and really wrapped my head around this, and like, okay, we need to help our clients here. One of the things on the FinCEN website that said existing reporting companies should engage with their beneficial owners to advise them of this requirement and obtain the required information, and revise or consider putting in place mechanisms to ensure that beneficial owners will keep reporting companies apprised of changes. So I really, in thinking about what can HOAs do? I think there's a couple things that HOAs can do right now. One is to consider amending your bylaws, election rules, code of ethics, to require that directors have to cooperate in the filing of providing information in the filing with CTA and any other reported or required filing requirement. I said earlier, there is a bill currently before the California legislature that has a similar Corporate Transparency Act beneficial owner information that would have to be filed with the Secretary of State. So we want to put that requirement into a governing document. And I actually would take it a little bit further too and say that a majority of the board could vote to declare vacant the seat of any director who didn't cooperate. Again, because those penalties are so substantial, $10,000 fine, $591 per day, that I think it would give the rest of the board the basis to declare the seat vacant of a director who failed to cooperate. Now, I'm not just saying they didn't respond to one email. It would have to be showing that there's a deliberate and willful intent to not provide the information to comply with the CTA requirements. The other thing I think that associations should be doing is in the call for candidates for the annual election, they should let the members know that if the person does put their name in nomination and they are elected to the board, that they will have to comply with the CTA filing requirements, and again, any other state mandated beneficial ownership information filing requirements. So those are a couple things I think that associations should really be looking to do now to have a mechanism in place to compel directors to cooperate.
Good. And the next slide, I was just going to go over a little bit about who I am and how to use CTA review. I'm going to go over this real quick because I want to get to the FAQs, or not FAQs, the actual questions from people attending the webinar. So get ready, Miranda. I think we're almost ready for you. If you want to use CTA review, it's a quick 3-step process. We are an actual service provider, so we're not just giving you a platform to use. We are going to be doing a lot of this for you. Again, my name is Natalie Stewart, and I've been in this industry for over 20 years now. I also own FHA Review, so we are a third-party submission service for condominiums who are seeking FHA and VA certification. So starting CTA Review fit right into that wheelhouse of being a third-party submission service that files on behalf of associations. So if you have any more questions or you want to see a little bit more about our service, you can go to ctareview.com. There's 2 videos there. One is very detailed about using CTA Review, or you can give me a call and we'll set up a Zoom meeting with you and your team. But let's get to the actual questions. Miranda.
Hello, everyone. Okay, so we had a lot of the exact same questions, so I'm just going to review with everyone. Please, if you weren't here or you were here, review the webinar again, because a lot of the questions that were asked were answered as we were going along. So I'm going to just try and pull out the ones that I don't think were asked. Okay, are you able to tell me where exactly and when I have to file?
Yeah, you need to file by January 1st, 2025 if you're an existing entity. If you're new, within 90 days of formation.
And new means formed after January 1 of this year. So for most associations, if you've been around and you were not created after January 1 this year, it is by January 1, 2025.
And they want to know where, like the website?
It appears so.
Yeah,
I mean, if you can go to Google FinCEN BOI reporting and it'll come up right there.
I saw that Rachel, I believe Rachel posted the website in the chat.
Okay. I was going to say, it's a funny one. It's not like FinCEN.com. There's other things in there, but it's very easy to find online with a quick Google search.
Should this be shared to the membership in general or just boards? As a board member, why am I considered a beneficial owner even though I don't actually own anything other than my own unit?
Laurie.
So again, the beneficial owner, it is individuals who directly or indirectly own or control the entity. So because you are on the board and you are the one making decisions, you are considered a beneficial owner. Again, it's vague as far as whether it has to be all the board members. We're saying best practice, and based on our best interpretation of the law, is we do believe in the context of an HOA, it is all the directors. And as far as telling the membership, like I said, in your call for candidates, I think you should tell the membership, certainly in the call for candidates. I think anybody who's putting their name in to run for the board, they need to understand that their information is going to have to be provided to FinCEN within 30 days of them getting on the board.
All right, next question. I filled out the CTA form at the bank when opening a CD for our association. Will this count for our association?
I
I don't know what that is.
that is, yeah.
Yeah, I doubt it. Let's
It'd
put
be
it this way.
100%, yeah.
Yeah, I doubt it.
Are HOAs required to submit to SOS and FinCEN?
So if you're talking about the California Secretary of State, there is a requirement that all associations, whether you're incorporated or not, you do have to file certain information on a biannual basis. There's a statement of information. There's a common interest development statement. Those have to be filed with the California. I'm talking about California only. I don't practice in other states. FinCEN is yes. So.
Can members use one login to do all the reports, or does each HOA have to have a separate login account?
Natalie.
There's no login on the FinCEN reporting site, and that's because you can never go back to get your report. It's just public. You fill out a form and then you press send and it goes away. There's a thing called the FinCEN ID that we didn't get in today that would require a login. That's each individual beneficial owner can apply for this same information, and then they would get that. But there's nothing that would mingle the two together with one login. There's one report with all the beneficial owners on it.
And that's the benefit of going through a company like yours, is because they could pull up that report. Am I correct?
Oh, 100%. Yeah, we create the report for the association. The members come in and then we populate it like this. And then you have one little, place that it's all housed in our database. Our database is completely secure and private, so there's no login. You just send your information through a portal and it populates on the backside.
Wonderful. Do our bylaws need to be modified or otherwise updated to meet the requirements of reporting?
Yeah, again, we recommend, I would say if you're in the process of restating the documents, it doesn't hurt to put something in there that really gives the board, I'm really looking for something that gives the board a mechanism to declare the seat vacant of a director who does not cooperate in providing the information to be able to comply with the Corporate Transparency Act or a state mandated similar reporting requirement. And it's similar in California, at least it's similar common practice is to have in the bylaws or the election rules that a seat could be declared vacant if a director misses a certain number of meetings. You see that language a lot. So I'm kind of thinking in the same way, is that it's detrimental to the association if you have a director who doesn't attend meetings. It's detrimental to an association to have a director who's not cooperating in the filing of the information. And so that could justify the rest of the board making a decision to declare that person's seat vacant.
Co-ops required to report all members as they are all equal owners.
So I'm not 100% up to speed on the logistics of how a co-op operates, but I have a feeling that a co-op's attorney would definitely be able to give an opinion on this. I honestly have not dealt with a co-op in doing, I don't know how many we've done. No co-ops have come across my desk. I think, I don't know how they're generally handling it, but I'm not sure. I would say legal counsel, Laurie.
Yeah, I mean, I would say for co-ops, they should consult with that's a very specific animal, and they should really consult with legal counsel specifically to get an opinion on whether they have to file. I mean, they are a corporation, so whether they have to file who's the beneficial owner, that type of thing.
Pretty sure we kind of touched on this a minute ago, but I'm going to say it again. What do I say to fellow board members that say things like, we do not want to do this?
Then do you want to spend up to 2 years in prison? Do you want to spend up to 2 years in prison? That would be the answer. Pack your toothbrush.
There's your answer. Because not all of the laws for us actually have like fines or fees or anything like repercussions right away. And we don't have a governing entity. So sometimes people can get away with this stuff, but this doesn't seem to be like that. Correct?
I mean, yeah, the ability of CTA to enforce and figure out that there are entities that didn't file. You know, I'm not sure what their ability is to track that and figure that out. I just don't know that I would want to leave it up to chance that there could be some other cross-referencing or some other situation where it does become apparent that there was a willful non-compliance to, you know, with the reporting.
Rumor I heard a while back is that if the IRS, they have your tax ID and they can compare it to people who are missing from the beneficial owner report database, then it would be a parent who is not filing. I don't know. That seems like it takes a lot of energy to then do that. I don't think that's going to happen, but I did hear that that's a capability that this does have to identify those associations that did not comply.
Well, and what about that angry homeowner who doesn't like the board and figures out that the board didn't comply? That's where it's going to come from. That homeowner is gonna. I
don't know who that homeowner is going to call, because I've called FinCEN and I've emailed them and they're going to get an AI response. But yes, that angry homeowner that tries to tell on their own association to get their own association penalized should always be watched out for. So
yes, I mean, they go to the Attorney General, they file complaints with the Attorney General of of California. So, you know.
To trickle down, that's for sure. Okay, where can we find the exemptions? I reviewed the CTA and could not find exemptions listed.
Yeah, the best source I found for the exemptions is they have, if you go to the FinCEN website, there is a link to what's called a guide. There is a guide for the beneficial ownership information. And it's in that guide. Although under the FAQs too, under the FAQs on the FinCEN website, question C2 has the list of the 23 entities that are exempt.
Yeah, and I have all of that information. If anybody just wants to shoot me an email, I can send you a link or a copy if you can't find it, because there's a lot of information on that website. So you can definitely shoot me an email and I'll send you to the right place.
Get it? Yeah. All right. Do non-incorporated HOAs not registered with the Secretary of State have to register?
Yeah, so again, this is one of those ambiguities that we talked about. The reporting company is a company that is, quote, created by the filing with a Secretary of State or similar office in other states. So our best guess right now is that unincorporated associations in California that are not created by the filing of articles of incorporation, there is a good argument that you are not deemed to be a reporting company and would not have to comply. But you should really reach out to your legal counsel and get an opinion from your legal counsel.
Because we don't know how it's going to pan out. So we want to make sure that they're all
well, and they can't say I attended a webinar with exactly. And heard this as a defense necessarily to a willful noncompliance.
Yeah, this is just giving them a step in the right direction.
Exactly.
Is it directors or officers or both that have to file?
Well, again, the definition of beneficial owner is an individual who directly or indirectly exercises substantial control over the entity. So, you know, again, that's a very specific question. And I would say if there are officers that are non-directors that have decision-making authority, things like that, you want to consult with legal counsel to see if those individuals would need to also report.
So in the situation of a fine, who gets fined? The HOA or the individual who is not compliant?
Good question.
Yeah,
go ahead.
I was going to say it's not clear. But what has been tossed around in a lot of conversations that I've been a part of is that the criminal penalties might be levied against the individual who did the willful noncompliance, and then civil penalties would be possibly issued against the entity. Laurie,
or both. There were somewhere on the FinCEN either FAQs or the website where it did basically say both.
Yeah.
So how that both is interpreted. Again, you can't send an HOA to jail, to prison. So it's going to be an individual, but the civil penalties, you know, and I think if FinCEN can find a way to impose it on both, they'll impose it on both.
I think we'll do one more and then wrap it up. Can you cover whether master associations are considered beneficial owners?
Of a sub association, I'm assuming. So of a master association would be a beneficial owner of a sub.
Mm-hmm. Mm-hmm.
I'm so from the traditional setup that I've seen, the master association is going to register as their own reporting company and beneficial owner, but they don't have a seat on the board. Their governing documents, Laurie, am I wrong? Their governing documents then kind of guide how the sub association.
Yeah, you know,
operates.
Like delegates or
again,
Yeah.
that's a pretty specific question, and I think legal counsel for that master and sub are going to have to look at it and give opinions. I mean, it seems like the boards of each entity are going to have to report in, you know, for their companies. I guess it would depend whether any of those directors do have substantial control of the other entity.
so if you're dealing with delegates on a master board, they don't really have a vote, then yeah. Okay.
Honestly, though, I'm going to tell you about the actual reporting mechanism. If you've got a board of directors on a master community and you're very concerned about them possibly exercising substantial control and being considered a beneficial owner of the sub association, you might as well just file it. They, you know, and it over reporting isn't
Yeah.
going to penalize you.
Yeah,
And they're already giving their information. And honestly, if you use a service like ours or another service, you just need to send the email address and stuff, and we link them up. So it makes it easier. But I would say over reporting in a situation like that, I cannot see how it hurts.
yeah. Good point, because if the board members of the master are going to be submitting on behalf of the master, so why not? Yeah, good point. Yeah, and as a best practice.
If you're very concerned, that I would recommend that.
Yeah. Again, it really, I think, would also depend on what the documents say as far as how much control the master board has over the sub.
Still seek legal advice, everyone.
Identifying
This is just
beneficial owners is
point.
difficult. It's
Yeah.
not, it's very vague, and it's not black or white.
No.
And all of our associations are very different from each one, and they're meant to be like that.
Yes.
Like tiny
Yeah.
snowflakes.
Exactly. Exactly. Well, I
Or
think we'll go ahead and wrap.
tiny little.
Yeah.
Thank you again to all of our attendees and speakers. As always, please do not hesitate to reach out to us with your questions, and we hope to see you next time.